I'm Ryan Heath. Welcome to Saving Gen Alpha. This show exists for one reason, because it's better to use a gavel than a gun. And I mean that literally. When people lose faith that the courts can protect them, when they learn that peaceful legal action can ruin them financially, something replaces the gavel. And whatever replaces it, it is never civilized. Today's episode is about a case that most Americans have never heard of, but that may become one of the most dangerous civil rights precedents in modern American history. GW, the Coronado Unified School District. This case is about a teenage girl who protested a government policy. She tried to stand her ground peacefully. She tried to use the system. And now a government school district is trying to collect over $100,000 from her and her family. That number isn't symbolic. It's real. It's enforceable. And it's the kind of debt that destroys lives. Everything we're about to discuss is grounded in public court records and filings, including the emergency stay application now being prepared for the U.S. Supreme Court. This episode is educational. It's not legal advice, but it's also a warning. So let's start with the human story. In early 2022, actually starting back in the beginning of 2021 school year, Coronado High School required students to wear masks indoors. GW was a student. And in January of 2022, after 6 months of suffering and being unable to breathe freely in class, she began to come to school without a mask, intentionally, as a protest. She wasn't screaming. She wasn't violent. She wasn't threatening anyone. She was, by all accounts, doing the most American thing possible, peacefully dissenting. And here's what happened next. Instead of letting her sit in class while they handled the issues through normal discipline, instead of dealing with a perfectly healthy child who did not have COVID-19 like a typical school would, the adults did something that should disturb every parent in America. They alienated her, not just socially, not just emotionally, but physically. They forced her for 6 weeks to sit outside the classroom doors in the freezing cold, in the scorching heat. They made her participate from the hallway, from random corners of campus via Zoom. Often she wasn't even allowed to access her class. And if you've never thought about what it means for a teenager, let me paint a picture. You're 15 or 16 years old. You're already self-conscious. You're already trying to survive socially. You already feel like the world is watching you. And now you're being treated like a biohazard, like a leper. The filings describe GW as being excluded from instruction, made to endure cold and heat, and subjected to humiliating treatment by the people who were supposed to be caring for her. And then came the moment that, as a parent, makes my blood run cold. During an emergency and lockdown drill, because GW didn't want to wear a mask like her sheepish classmates, she wasn't allowed to lock down with them. Instead, she was instructed to shelter in a nearby bathroom, one that didn't have an interior lock on the door. Let me translate that in plain English. In the event of an active shooter, which is what this drill was for, the school's solution was simple. You don't get to have the same protection as everyone else. If that doesn't make you angry, I don't know what will. This perfectly healthy child who did not have COVID-19 and was not disrupting her classmates, all she did was go into class, peacefully take her mask off, and sit down. When they asked her to put it on, she just said no thank you. She was suspended twice for this. She was threatened with discipline repeatedly, and she was marked as unexcused. The school district threatened to file truancy charges against her mom. After several months of abuse, GW was completely at a loss. So she disenrolled. In August of 2022, GW and her mother, Nicole Ward, with the help of the Gavel Project, filed a lawsuit claiming civil rights violations and other claims. And here's the key point. This case was not simply about whether masks work. We know they don't. We knew then that they didn't work. Masking has never worked to slow a respiratory virus in the history of humankind. We knew that at the time. There's not a single credible scientific study backing up the mask mandates that were forced down our throats by our government. This case is about whether the government can respond to peaceful dissent with coercion, humiliation, and exclusion. Because in America, even if the government thinks you're wrong, you're still allowed to dissent. At least that's what the First Amendment stands for. Now I have to teach you about something that most Americans have never heard of. It's called anti-SLAPP. SLAPP, spelled with 2 P's, stands for Strategic Lawsuits Against Public Participation. Anti-SLAPP laws, which exist in the majority of states across this country, were created to protect citizens. Here's the classic scenario. A powerful person gets mad that you spoke up publicly about what they're doing. So they sue you, not because they expect to win, but because they want to ruin you financially. They want to bankrupt you. So anti-SLAPP is supposed to stop that. The anti-SLAPP process works very specifically according to the statute. You actually have to follow, as a court, a 2-part test before you can dismiss a case. And the first step is on the defendants. It is their burden to prove that the lawsuit, the reason they were sued, is because they were engaged in protected speech or petitioning activity. Meaning, you sued me because I spoke publicly about an issue of social concern. In other words, anti-SLAPP applies when you sue someone for furthering the public discourse on an issue impacting our society. And here's the huge part. If the defendant wins, the plaintiff must pay their attorney's fees. It's mandatory. That means anti-SLAPP isn't just dismissal, it's punishment for filing a suit to vindicate your rights. Now let me explain anti-SLAPP with an analogy that you'll never forget. Imagine this. You are a regular person. Your city is dumping chemicals in the water. So you sue the city, and you show up to court, and the city says, your lawsuit is attacking our protected activity because we held meetings and passed a policy months ago that allowed us to dump these chemicals into the water. And the judge says, case dismissed. And the city says, also, you owe us $100,000 for our lawyers. That's what anti-SLAPP becomes when it's misused. A statute meant to protect the public from powerful bullies turns into a weapon for powerful institutions to financially destroy the public and shut down dissenting viewpoints. In this case, the defendants filed 4 anti-SLAPP motions claiming that punishing a child, aka child abuse, to shut down her dissenting viewpoint was free speech. The trial court granted all 4 motions, and the Court of Appeal affirmed. At the same time, however, the Court of Appeal explained something that should make every American's jaw drop. The appellate court admitted it couldn't even properly assess the first step in the analysis without a proper factual summary of what each defendant allegedly did and said. And instead of reversing, because that was not in the record, it blamed the plaintiffs for not providing what the defendants were required to provide. That's the inversion. The statute explicitly requires the defendants to identify which of their statements and actions were protected activity. And to date, they haven't done so. And no court has explained how shutting down a dissenting viewpoint to enforce a government policy that pre-existed the protest was protected speech. Instead, the court shifted their burden onto the plaintiffs. That's not just unfair. That's due process destroyed. Now we have to talk about the May 2023 hearing, because this is where the public needs to understand something very clearly. This did not look like neutral judging. It looked like a court picking a predetermined outcome. During the hearing, the judge compared GW's unmasked presence, while perfectly healthy, to bringing a gun to school. I'm going to quote the court. "Guns kill, and so does COVID," end quote. Sit with that. Because that statement alone tells you how the judge framed this case. Not as student protest, not as a constitutional question, not as a civil rights dispute, but as a public danger. And once a judge has decided that you are a danger, everything you do becomes a disruption. Everything you say becomes a threat. Everything you claim becomes frivolous. The judge repeatedly stated that he would take, quote, judicial notice, end quote, of disputed scientific facts, including the fact that GW was an asymptomatic carrier of COVID, even though she provided the court with a sworn declaration attesting to the opposite, and even though the court was required by law to accept her allegations and her sworn statements as true. That is not the mindset of a court carefully applying a statute. That is the mindset of a court justifying its predetermined outcome. Now let's explain what it is that GW claimed when she said she was engaging in free speech, because that's what we were suing over. The First Amendment protects not just your words. It also protects actions that clearly communicate a message to a reasonable observer. This is called symbolic speech, and there are classic examples. For instance, wearing an armband, kneeling, burning a flag, wearing political clothing, refusing to participate in compelled rituals like standing up for the Pledge of Allegiance. Those are all protected activity because people seeing the refusal or seeing you engaging in that action understand what it is you were trying to say with your expressive conduct. So the question the court is supposed to ask is, would a reasonable observer understand the message based on the context? In this case, GW wasn't merely forgetting a mask. She was walking into class with one on and taking it off as a show of defiance. She did it intentionally, repeatedly, politely, as a form of protest. Every single one of her friends in that room knew it. And that's why the response escalated, because it wasn't about fabric. It was about defiance. Think about it this way. Imagine that you walk into an airport today and you see someone in a mask. If they're not sick, they're wearing it for another reason. They're expressing a viewpoint with that article of clothing. You know which team they're on already, based on the fact that they're wearing a mask in public. So here's the constitutional inversion. Anti-SLAPP is supposed to protect free speech. But here, anti-SLAPP was used to destroy the lives of individuals engaging in free speech. And even worse, the government's enforcement actions were treated as protected activity, meaning the government shutting down dissenting viewpoints became the thing protected, and disagreement became the thing punished. That is upside down. The First Amendment is supposed to protect citizens from government retaliation when they are engaged in free speech. It is not intended to protect government retaliation from citizen lawsuits. So here's where the punishment becomes real. The school district is attempting to collect over $100,000 from GW and her mother. And the Court of Appeal imposed a sanction on counsel of $13,000, plus state bar reporting consequences for pointing out the fact that the court dismissed this case without engaging in the first prong of the mandatory analysis. In other words, because the court acted without jurisdiction in excess of the explicit jurisdiction conferred by the anti-SLAPP statute, which requires the court to engage in a two-prong inquiry which never happened, she was sanctioned for it. That's not just a slap on the wrist. It's financial annihilation. This is the government saying, if you sue us, we will ruin you. Now let's get to the real danger here. If the Supreme Court does not accept review, this becomes the lesson. Peaceful protest is allowed until the government disagrees and punishes you for speaking out. And if you sue us, it's going to cost you your future. And it gets worse because anti-SLAPP statutes exist in most states. If California's new approach spreads, the precedent becomes civil rights claims can be dismissed before discovery, government defendants can avoid their statutory burden, courts can treat enforcement as protected speech, and plaintiffs can be punished financially for petitioning their government for redress. It doesn't just chill free speech, it destroys it. You will no longer have the right to dissent if this precedent stands. And when citizens learn that courts are not safe, they stop going to court. They stop believing in the rule of law. And when the gavel fails, people reach for something else. That's how societies collapse. So right now, we submitted an emergency stay application on Wednesday electronically. That was February 4th, seeking to prevent enforcement while the Supreme Court review is pursued. The petition for certiorari, which we will be filing soon, is due by March 30th, 2026. So whether you agree with GW about masks is irrelevant. The question is, should the government be able to financially annihilate a family for suing to vindicate their constitutional rights? Do you have the right as a U.S. citizen to dissent peacefully from compelled conformity of thought? Or are you just a slave? If this case isn't overturned, the First Amendment becomes a luxury item. If you want to support this fight and help us fund our U.S. Supreme Court counsel, the Gavel Project is raising support now. You can support this case by making a tax-deductible donation on our website, thegavelproject.com. This case will decide whether peaceful dissent is still allowed in America. All right, and just an addendum to today's episode, I just want to make sure if anyone has any questions about this, I understand it's a complex legal issue. Put your questions in the comments below. I'll respond to those questions during the next episode. And this is part one of a two-part series. We're going to have Nicole Ward and Tracy Henderson fly out from California to join me here in Arizona at the beginning of March. And we will release the episode talking about how all of this happened, my interactions with the family during the protest, really the background story of this case. You'll get that in the part two to this series. So tune in then. Thanks.